किसी को भी फंसा दोगे ऐसे तो आप किसी का केस अपोज करते हो। कल गुप्ता जी ने आपके खिलाफ लिखा दी 1 FIR। गुप्ता जी उपाध्यक्ष रह चुके हैं बाद के। तो असत्य है, उसका बच्चा ही नहीं है। वो किसी और के साथ जाए, वो XYZ के साथ जाए और आपका नाम ले दे। लड़की चीफ में बोलती है कि मैं अभियुक्त को नहीं जानती। होस्टाइल डिक्लेयर करने के बाद बोलती है मैं इसके साथ दिल्ली गई थी और जो बच्चा है वो इसी का है। DNA रिपोर्ट कहती है कि ये बच्चा इसका नहीं है। DNA रिपोर्ट पॉजिटिव है क्या? चलिए खैर आगे बताइए। हाँ पढ़िए।
प्रोसिक्यूशन मिला
मैनेजर PW2
PW2 मिला। मैं हाजिर अदालत आरोपी कमलेश पटेल को नहीं पहचानती हूँ। मैं 15 वर्ष की हूँ। मैं कक्षा 8वीं तक पढ़ी हूँ। मेरी जन्म तिथि 2-3-5 है। मेरे साथ कुछ नहीं हुआ। मैं कभी थाने नहीं गई।
तो मैंने आपसे पूछा DNA रिपोर्ट क्या कह रही है?
DNA रिपोर्ट हमारी फेवर है मिला।
आप नेगेटिव है?
जस्ट
क्या कहाँ है वो एग्जिबिट C?
P1 मिला। इसको जैविक पिता भी नहीं माना मिला, हमको मिला। इसका एक बच्चा है।
ठीक है समझ गए। बोलिए। यस सोनी जी। प्रोसिक्यूट्रिक्स इज होस्टाइल, DNA रिपोर्ट इज अगेंस्ट। क्या करना है उसके बाद? ऑक्सो क्या हो जाएगा जब उसका है ही नहीं? आप किसी को भी फंसा दोगे ऐसे तो आप किसी का केस अपोज करते हो। कल गुप्ता जी ने आपके खिलाफ लिखा दी 1 FIR। गुप्ता जी उपाध्यक्ष रह चुके हैं बाद के। तो बताओ ना किस आधार पे कन्विक्शन मेंटेन करेंगे? आप तो बताओ, वो आपको सुनेंगे। On what basis conviction is to be maintained, especially when prosecutrix has turned, मतलब in examination in chief itself she has said that इस आधार पे कन्विक्शन क्या पढ़े ना थोड़ा, इट इज इंटरेस्टिंग।
ये बायोलॉजिकल रिलेटिव बताइए, मदर नहीं बताइए आयुष।
पैरा 29 जजमेंट में अभियुक्त की यद्यपि अपने मुख्य प्रशिक्षण में आरोपी हलशंका किया जाना व्यक्त नहीं किया है, किंतु पक्षद्रोही घोषित किए जाने के पश्चात उसके द्वारा आरोपी के साथ दिल्ली ले जाने
तो असत्य है, उसका बच्चा ही नहीं है। वो किसी और के साथ जाए, वो XYZ के साथ जाए और आपका नाम ले दे। भाई DNA रिपोर्ट या तो असत्य है, आपको चुनौती देना चाहिए थी DNA रिपोर्ट को। She had liaison with somebody else. She has implicated this gentleman. उसने तो कह दिया, लेकिन is it scientifically corroborated? There could have been another circumstance, Mr. Soni, that DNA report would have been uninterpretable.
Yes.
If uninterpretable, then benefit of doubt would not have accrued in favor of the accused. Because uninterpretable will not never cause, then we will have to corroborate that uninterpretable with the evidence of the prosecutrix in such matter, because she is the victim in the first place. But when the statements of the prosecutrix are not corroborated with the medical evidence, then what will be the situation? ताम्रकार जी थोड़ा सा असिस्ट कर दीजिए, नाम आपका नहीं डालेंगे सर। समझ रहे हैं आप बात को? सुना कि आप कहीं और खोए हुए थे?
मैं पढ़ रहा था।
कहीं और खोए हुए थे ना? सुनिए, मुकदमा यह है, लड़की चीफ में बोलती है कि मैं अभियुक्त को नहीं जानती। होस्टाइल डिक्लेयर करने के बाद बोलती है मैं इसके साथ दिल्ली गई थी और जो बच्चा है वो इसी का है। DNA रिपोर्ट कहती है कि ये बच्चा इसका नहीं है। फिर प्रोसिक्यूट्रिक्स की क्या क्रेडिबिलिटी बची?
अब बच्चा कोई है ही नहीं है तो
खत्म ही हो गया।
गलत खत्म ही हो गया।
चलिए बैठिए देखिएगा।
In fact, my lord, only summation would be that in some of the judgments, my lord, DNA report is also not exactly said to be conclusive, कि सिर्फ उसके ऊपर लाए करके।
तो आपको करना चाहिए था ना, ये आप ही का तो डॉक्यूमेंट है, ये प्रोसिक्यूशन का डॉक्यूमेंट है ना। You should have come out that my document is incorrect. You should have led evidence.
I am not saying that it is incorrect. I say, my lord, that it cannot be said.
तो जी आपका नुकसान हो गया, फाइनली लिखा दे रहे हैं, आगे की फीस नहीं मिलेगी। देखिएगा
एक बार बस पैरा 30 बस एक बार
पैरा 30 पढ़िए प्लीज पढ़िए।
I'm reading from the 5th-6th line, मतलब पोस्ट पैरा 30। इसके अतिरिक्त यहाँ तक प्रदर्शित एक DNA रिपोर्ट
एक मिनट, इसके अतिरिक्त
जी DNA रिपोर्ट में आरोपी कमलेश अहिरवार के बच्चे का जैविक पिता न मानने के संबंध में जो अभिमत व्यक्त किया गया है, तो यह अपने आप में ही बलात्कार के विषय में अभियुक्ति के साक्ष्य पे किए जाने का आधार नहीं बन जाता, क्योंकि बलात्कार के अपराध के लिए यह आवश्यक नहीं है कि यदि अभियुक्ति से कोई संतान उत्पन्न हुई हो तो यह स्थापित किया जाना चाहिए कि अभियुक्त उस संतान का जैविक पिता है। इसके अतिरिक्त 6 डॉक्टर आर के पटेल द्वारा अभियुक्त के संभोग समक्ष
क्या
होने-
लिख रहे हैं भाई, क्या
ये
लिख रहे हैं?
एक
जैविक पिता किसी और से, बलात्कार किसी और से,
ये कहना
इनके खिलाफ हमें जांच के लिए लिखना पड़ेगा, इनकी फाइलें लेनी पड़ेंगी इंस्पेक्शन के लिए। क्या लिख रहे हैं? इज देयर एनी
I think-
मतलब ये हो गया कि हम यहाँ बैठे हैं कि गुप्ता जी के जितने केसेस आएंगे या XYZ वकील साहब के जितने केसेस आएंगे उनमें कन्विक्शन ही करना है। तो इस मनस्थिति के साथ तो हम फिर जज कहलाने के लायक नहीं है।
what I
Please
can
try to understand.
con-
There should be some logic. There should be some reasoning.
जी,
The evidence of the prosecutrix has been falsified. What evidence she is giving after being declared hostile means that she had liaison only and only with the appellant and nobody else. Therefore, she is saying with certainty that the child which is born is biological, is appellant is the biological father of that child.
I totally understand that.
And what kind of reasoning he is giving? I'll have to order inquiry. We will have to order inquiry against this gentleman. We'll be ordering that soon. Don't worry. Listen to us now. देखिएगा.
इसमें एक और प्रॉब्लम, डीएनए रिपोर्ट में मदर नहीं लिखा, रिलेटिव लिखा है। रिलेटिव मींस बहन भी हो सकती है, कुछ भी हो सकती है।
अगर
वो बहुत फंडामेंटल मिस्टेक है मेरे हिसाब से। रिलेटिव कैसे लिख दिए?
इससे जो कंस्ट्रो कर पा रहा हूँ मैलॉर्ड, उससे ये बताना चाह रहे हैं कि अगर किसी के साथ एक्ट हुआ भी है और पिता कोई और है तो इट इज नॉट दैट कि एक्ट ही नहीं।
मदर
ये
तो चलिए ठीक है ना, तो उसको फिर ये बोलना पड़ेगा कि मेरे
आप
मेरे
prosecutor
दो तीन
से
लोगों से
statement
संबंध, मेरे
सही।
दो तीन लोगों से संबंध थे, लेकिन जो है भले ही ये बायोलॉजिकल फादर नहीं है लेकिन इसने मेरी प्रिवेसी वायलेट
Yes,
की है,
yes.
ये स्टेटमेंट उसको स्पेसिफिकली देना पड़ेगा।
बट इन दिस केस मैलॉर्ड उसने स्टेटमेंट कुछ और दे दिया, दैट इज व्हाई केस
बस खत्म हो गया, वो इसीलिए तो खत्म कर रहे हैं।
आई टोटली
हाँ,
अंडरस्टैंड।
और इनकी जांच के लिए आपने पॉइंट आउट करके इनकी जांच और करवा दी।
नहीं मैलॉर्ड,
Just some-
पॉइंट आउट सिर्फ ये बताना चाह रहा था जजमेंट किस पे बेस्ड
हाँ, इनकी जांच होगी ना, आप क्यों चिंता कर रहे हैं? आप
नॉट रिक्वायर्ड।
नहीं, it is required
जुडिशियल
because if they do not understand that what is to be, how the evidence is to be appreciated, then they are required to be given training.
ही इज हैविंग हिज ओन जुडिशियल माइंड।
हाँ ठीक है ना, we are not disputing that, we are not disputing that. चलिए, this appeal is filed being aggrieved of judgment dated 17/7/2023 passed by learned third additional session judge Nagaur district Satna in SC number 22 of 2020. Full stop. It is submitted that as per the prosecution case on 25/10/2018, prosecutrix along with her mother had appeared before police station Jasso and had made a report that on 22/10/2018 at about 8 a.m. prosecutrix had left her home. Prosecutrix aged about 13 years had left her home along with her school bag. Full stop. When she did not return after the school was over, then she was searched for in the nearby village, but on not getting any clue about the whereabouts of the prosecutrix, matter was taken up in investigation, and thereafter prosecutrix stated that appellant Kamlesh Airwar had taken her to Delhi. Full stop. She was kept in Delhi where she became pregnant with the appellant and appellant. Full stop. On such allegation being made, appellant was arrested. Case was registered under section 363, 366, 376 and 5/6 of POCSO Act. Full stop. Thereafter, trial was conducted, and on the basis of the evidence which has come on record, conviction of the appellant has been recorded under section 366 IPC with 3 years RI, fine of ₹100 with default stipulation of 3 months RI. Full stop. He has been also convicted under section 376 within bracket 3 IPC with 20 years RI and fine of ₹500 with 6 months default stipulation of 6 months RI. All the sentences to run concurrently. Next paragraph. Learned counsel for the appellant submits that appellant is innocent. He has been falsely implicated. Full stop. Prosecutrix in her examination in chief has stated that appellant is not known to her. Full stop. Thereafter, prosecutrix PW2 है. She has stated is not known to her. Full stop. She stated that her date of birth is 2/3/2005. Full stop. Nothing had happened with her. She never visited police station. She never gave any statements in the court. She denied her signatures on her statements under section 164 CRPC, Exhibit P1. She even denied her medical examination. Full stop. Thereafter, it is pointed out that in the DNA report, Exhibit क्या है DNA रिपोर्ट? यश जी आप ही बताइए, गुप्ता जी से उम्मीद नहीं कर रहे हैं हम.
एग्जिबिट P1 कहाँ है? विधि विज्ञान प्रयोगशाला का पत्र P19
P19
विधि विज्ञान प्रयोगशाला का पत्र दिख रहा है.
P19 नहीं है. P19 तो DNA सैंपल भेजने का. Exhibit C1. It is mentioned that
C1
blood sample of the infant is Exhibit C. That of the prosecutrix is Exhibit B, and that of the appellant is Exhibit D is packet D. Exhibit B, C, and D. ठीक है ना? Full stop. As per the testing, it was found that prosecutrix is the biological relative of the infant Exhibit C, whereas appellant Kamlesh Ahirwar Exhibit D is not a biological father of Exhibit C. Full stop. Thus, it is pointed out that when prosecutrix admitted that she was not knowing the appellant and had no liaison or relationship with the appellant, which is proved through scientific evidence Exhibit C1, then conviction on the basis of presumptions and surmises is not called for. Appeal needs to be allowed and be allowed as such. Next para. Shri Yash Soni, learned Deputy Advocate General for the state, in turn reads para 30 of the impugned judgment and submits that trial court has considered various aspects and has said that despite the fact that DNA report is negative and PW7 Dr. Jaspal Beena has stated that there were no injury marks on the private parts of the prosecutrix and no definite opinion can be given in regard to intercourse, other evidence available on record cannot be discarded. Full stop. After being declared hostile and subjected to leading question, prosecutrix has stated that क्या लिखा? Sorry. जितना leading question वाला हटा देना. It is stated that non-production of child is not a sufficient circumstance to deny the evidence of intercourse, especially when PW6 Dr. R.K. Patel found the appellant to be capable of performing intercourse, and on that basis, since conviction has been recorded, it is a sufficient circumstance to uphold the conviction. Next para. After hearing learned counsel for the parties, PW2 prosecutrix has clearly stated that she did not recognize appellant Kamlesh Ahirwar. She has studied up to 8th class. Her date of birth is 2/3/2005. She stated that nothing happened with her. Full stop. She never visited police station. Full stop. Her statements were never recorded in the court. Full stop. Section 164 CRPC statements do not contain her signatures. Full stop. Her medical examination was not conducted. Full stop. Thereafter, she was declared hostile and leading questions were put to her. Full stop. She is denied that on 22/10/2018, she had visited Amoga and from Amoga to Delhi along with the appellant. Full stop. She denied that she was in love relationship with the appellant. She has denied that because of such love relationship, she had gone to Delhi. Full stop. She has admitted that she has a child and alleged that it is fathered by the appellant. Full stop. She admitted that she wants to live with the appellant. Full stop. However, in cross-examination, this witness has clearly stated that appellant never violated her privacy and he had not taken her to Delhi along with him. Full stop. When this evidence of the prosecutrix is examined in terms of the medical evidence of PW7 lady doctor, Dr. Jaspal Bina, who noted that there were no injury marks on the private parts of the prosecutrix. Her hymen membrane was whole tiered, comma, she was pregnant and had given birth to a child. And the prosecutrix was having all these symptoms which are available in a major person, then evidence of PW6, Dr. R.K. Patel, stating that appellant is capable of performing intercourse is not a sufficient circumstance, and prosecutrix herself stated in her cross-examination that no wrong was done by the appellant to her. She further admitted that she had not gone with the appellant to Delhi. Full stop. This fact is further corroborated with the scientific evidence of DNA examination contained in Exhibit C1, which says that child born from the womb of the appellant, womb of the prosecutrix, is not the biological child of the appellant. Full stop. Thus, we have no hesitation to hold that learned trial court recorded conviction without appreciating the evidence on record. Full stop. It firstly failed to read the cross-examination of the prosecutrix and secondly corroborate it with the DNA report Exhibit C1. And when these two facts are corroborated, then trial court has committed a grave error in recording conviction of the appellant and wasting his time in the jail, in the custody. Full stop. When tested, then then neither there is any first-hand account of the prosecutrix, nor there is any corroboration of the violation of privacy through forensic evidence. Then conviction cannot be upheld and it is being made on surmises and conjectures, needs to be set aside and is hereby set aside. Appeal is allowed. ठीक है ना, वो conviction under section इतना set aside, not required in any other case. Even एक line ऊपर और लिखना ना, even PW5 has admitted that at the time of the admission of the prosecutrix, her parents had not given any document in support of her date of birth or any birth certificate.
ओ बोला